Welcome back to DNT Law classes. So today we're going to discuss about the registration of trade union. So far we've discussed about in the previous class we've discussed about what a trade union is, its scope, objective of the Trade Unions Act of 1926 and few of the important definitions, and we've also covered one of the important case laws there. So in this session we shall discuss about the registration of trade union. So today we'll be focusing about the definition of registrar as per section 2 clause F, then section 3 to section 10. So let's get started. So before moving on to the topic, we can discuss about the importance of registering a trade union. As I've already mentioned, it is not mandatory, or the Trade Unions Act of 1926 has not made it compulsory for the associations to register themselves, and they can voluntarily register the trade union, and even if they don't, then it won't be considered as illegal, and it is valid as per Article 19 Clause 1 Subclause C. And as I've already said, if the trade union is registered, then it will get some immunities and protection against criminal conspiracy and civil suits, as we have already looked upon in the Buckingham Mill case. So let's move on to the next topic, that is the definition or the meaning of registrar. The registrar is defined under section 2 clause F. So as per the section, a registrar is a person, or a registrar of a trade union is a person who is appointed by the appropriate government as per section 3 of the act. So it also includes additional or deputy registrar. I guess further explanation is not needed. So let's move on to the next section, that is section 3, which is with regard to the appointment of registrar. So I've already said an appropriate government appoints a registrar, and moreover the qualifications that a registrar should confer is not mentioned in the act. It is as per the discretion of the appropriate government. And the next one is additional and deputy registrar can also be appointed, and when a registrar has been appointed, his functions and the local limits also should be defined. So let's move on to the next section, that is section 4, modes of registration. So any 7 or more members who, as I've already said, a trade union should have their rules, right? So any members who have subscribed their names in the rules of trade union or by any other provision of the act can apply for registration. So that means those who have subscribed their names in the rules of trade union. So each trade union will be having a rule. Okay, so such people, 7 or more, such people can apply for registration or by any other provision that is mentioned within the act. Okay, so employers can also, have already said, not only workmen but employers can also register their trade union, and trade union is registration of trade union is not compulsory, and we can also write all the other things that we have already discussed under this head. And let's move on to the next topic, that is section 5, application for registration. So far we have looked upon the meaning of registrar, that is enumerated under the section 2 clause F, and then we have looked upon section 3, appointment of registrar, section 4, modes of registration, and section 5, application of registration. So you have to connect it in order to by heart the sessions. So this session, that is section 5, deals with the application of registration. So what all should be there when a trade union makes an application to the registrar for registering the trade union? So first of all, an application has to be made to the registrar, and apart from the application, an accompanying copy of the rules of trade union has also to be attested with it, And the next one is a statements of the following should also been attested with the application form. That is name, address, in occupation of the person making the application. We have already discussed in the section 4 that in the modes of registration, that 7 or more who has subscribed their names to the rules of trade union can make application. So such people, the name, address and occupation of such person has to be there. So statement of such things has to be there. Then in case of the trade union of workmen, their occupation, address and place of work has to be there, and then the name of trade union and where its head office is situated, that is also to be there. So such statements with regard to such information should be attested along with the application. And if a trade union has existed prior 1 year, if a trade union has existed for a period of 1 year prior to the making of application for registration, then the general statements with regard to the assets and liabilities of the trade union should also be given. So these are some of the requisites that should be there while applying for registration. So moving on to the next section, that is section 6, which is very important, that is objects and rules. So one thing that we have to remember is that in section 6 there are certain provisions and certain important provisions that has to be followed by the trade union before filing for registration. So only after conferring to such provisions can the trade union make an application to the registrar for registering the trade union. That is, and as per section 6, the name of the trade union has to be there, and for the objects for which the trade union has to be constituted should be there. Then the minimum payment of subscription, so subscription that person has to pay, that should be there. For example, for rural workers the subscription amount is ₹1 per annum, and for other workers in other unorganized sectors it is ₹3 per annum, and for workers in any other case it's ₹12 per annum. So such should be mentioned, or such should be followed as per the provision of section 6. And these are condition precedents, that is these that a trade union has to confer to these mentioned in the section 6 before filing an application for the registration to the registrar, and the registrar should look into the application whether or not they have satisfied the condition precedent that is mentioned in the section 6 of the act, and if they have complied with the provision of the act, can he give the certificate of registration. So all the perquisites or prerequisites has been mentioned in the case Triloknath Tripathi versus Allahabad Division Bench. So it has been held that a trade union cannot be allowed to be registered unless the condition of making rules relating to the trade union are complied with. So I've already discussed the requisites. So next we can talk about section 7 of the act. So section 7 deals with the power to call for the alteration of the name of the trade union. Suppose while making an application to the registrar, if the registrar sees that the name of the trade union has close connection with the name of the existing trade union, he can call in for the alteration of the same. So the registrar has a power to reject the application if such conditions has not been satisfied. Suppose if he has given a notice with regard to the alteration of the name of the trade union and such has not been complied with, then the registrar can reject the application. So it is a duty of the registrar to look into such details. So it has been held in the case Tata Workers Union versus State of Jharkhand. So in this case, the court has held that the registrar does not have any authority to intervene in the matters with regard to the election of the office bearers, but he has the authority to look into the details of the application. So whether or not the same name has been used by the trade union that has given it for application, etc. So, as per the judgment, the Honorable Court held that it is a duty of the registrar to look into whether or not all the provision of the Act has been duly complied with. If he gets a clear-cut idea that such has not been complied with, then he has the authority to reject it. And moving on to the next section, that is section 8, registration of trade union. So after the aforesaid compliance of the provision, if the registrar is satisfied that all the provision has been duly complied with by the trade union, then he shall register the trade union by entering in a register to be maintained it's in such form as may be prescribed. So that is it. And one thing that has to be noticed is the registrar has to comply with the duties prescribed under section 7 and 8. So it is his duty to look whether all the name has been altered and proper provision has been complied with, that is the provisions that is mentioned under section 6, and if not, may attract interference of the court under article 226 of the Constitution of India. And it has been held in the case ACC Rajanka Limestone Quarries Mazdoor Union versus the registrar. Next, we can move on to the next topic, that is section 9, issuing of certification of registration. So we know that after the registration is done, the registrar shall issue a certificate of registration, and it shall be a conclusive evidence of registration. So moving on to the next topic, which is also very important, that is cancellation of registration of trade union or translation of certificate of registration of trade union. So under which all conditions can a certificate of a trade union or certificate of a registration of a trade union can be cancelled? So for the first one is on the application of a trade union, and the second one is if the certificate has been obtained by any fraud and certain other grounds are violated. So if a registrar finds that if an application has been obtained by means of fraud and if any provision is not complied with, then the certificate of registration can be cancelled. And some of the other reasons is that the first one we have already discussed, that is obtained by means of fraud, and the second one is trade union has ceased to exist, that is it has not conducted any meeting, any board meeting once in 3 months, and it has contravened with any provisions of the act. The next one is it has not complied with or has rescinded from any provisions of section 6, and the trade union does not have the required number. So under these all circumstances, the certificate of registration is cancelled, and the registrar cannot at once dismiss it or cancel the registration. He has to give 2 months a notice 2 months prior to the cancellation of the registration. And this is a very important aspect, that is before cancelling the registration of a trade union, proper notice has to be given for a period that is for a minimum of 2 months prior. And if the registrar has not complied with such an important provision, then any proceedings for cancellation is regarded as void. So such has been or such a decision was held in the case Hindustan Copper Mazdoor Sangh versus Chief Labour Commissioner. And next section is section 11. So as per section 11, if a trade union has been refused to be given registration, or if the registrar does not registers the trade union, or if the certificate of trade union is cancelled, and if the trade union is aggrieved by such a decision, then such an aggrieved party can approach to the court within the prescribed period, and the proceeding shall start within a period of 60 days of the date in which the registrar has passed the order. So that's all, guys. Thank you for watching. Hope all of you have understood this.